students, this is Jonathan Lipson with The Real Deal on Contracts. Today we'll talk about problems of fraud, misrepresentation, and good faith. If you're in my class, this corresponds to units 22 and 23. We'll really just talk about two things. Number one, sort of an overview of how courts deal with problems of fraud or misrepresentation in the context of contracts, and second, how courts think about problems of good faith, how they identify them, and how they address them. So first, fraud and misrepresentation. Fraud and misrepresentation basically involve the problem of what the economists would call information asymmetry, meaning things like who must disclose what and who bears the burden to ask. If you step back and think about it for a minute, right, every contract is going to involve some private information, meaning that every party is going to know something that the other side doesn't know. There's nothing necessarily exciting about that. What's exciting is when one party, fails to say something that's really important to the other side that they should have said, or says something that's affirmatively misleading to the other side. The traditional rule at common law, what Duncan Kennedy calls the core, was caveat emptor, right, which is just Latin for buyer beware. The buyer at common law, under the traditional approach, bore the burden to ask. The seller had no meaningful duty to disclose. The seller, it was the buyer's job to find out, what the buyer needed to know in order to figure out whether they were getting what they expected to get. The modern approach has, in effect, shifted this, so that sellers now, in fact, have pretty significant duties of disclosure. This paraphrases several sets of rules, but I think that you can think of the modern approach to fraud and especially intentional misrepresentation as being the misstatement of a material fact or omitting to state a fact that would be material on which the other party has reasonably relied, meaning that fraud or misrepresentation imposes upon the seller some duty to make affirmative disclosure, even if they're not asked. We have a nice quote from the Abdi case. Robert Keaton says, if either party to a contract or sale conceals or suppresses a material fact that he is in good faith bound to disclose, then his silence is fraudulent. Affirmatively lying, saying that something is, one thing when you know that it's another, is pretty easy to define as fraud. I think where things get more complicated is when you have misrepresentations that might be material, meaning they might be important, but they're not necessarily intentional or they're not intended to deceive. And so you have cases like Abdi v. Schleiermacher and to a lesser extent Volks, where people are not misstating affirmatively some facts so much as they are failing to disclose something that they know or should know would matter to the other side, which then begs the question, well, okay, not only does the seller have a duty to disclose what's important, but they also have some duty to investigate on their own part or on their own side and then figure out how to disclose it in that way. And that's where it gets interesting and tricky. Good faith, in one sense, is, I think, a little more complicated than fraud or misrepresentation. The key questions that we focus on with respect to good faith, I think, also involve a kind of information asymmetry, but not necessarily one that involves material misstatements. Instead, what we're asking about in good faith is, does one party have some affirmative duty to protect the other party, or is it really the case that one party only need avoid deceiving the other party? Or, as we often see the court say, when does behavior or breach become opportunistic? Opportunism is the conclusion that we come to that leads us to say some behavior was in bad faith. We do have a definition, a pretty straightforward definition of good faith in both the UCC and in the restatement. It's defined as honesty in fact, in the conduct or transaction concerned, and the observance of reasonable commercial standards of fair dealing. This is by most lawyers thought to mean that it has both a subjective and an objective test. Subjective is honesty and fact, sometimes called the clean heart and empty head test. The objective being reasonable commercial standards of fair dealing. What do other folks in the community, however defined, do in these situations? Which then, of course, begs the question: well, how do you define the relevant community? Market Street v. Fry's case we read on this. It's another Judge Posner special. I think it's a very interesting opinion. It's a difficult opinion for a variety of reasons. The deal itself is a little tricky, but I think it's also important to kind of think about, well, exactly why did the defendants have a duty to disclose or go further in disclosing what they were trying to do than they went? Why wasn't the language of the contract full and complete? Why was it okay to in effect impose a duty of good faith to perhaps change what might have been expected to be the outcome given the plain language of the contract? We'll talk more about this in class. Until then, that's The Real Deal on fraud, misrepresentation, and good faith.